Welcome all to my YouTube channel VaJee Law. Here I'm just come up with some fancy PPT, so I thought I should explain again. Okay, let's start. Here we are decoding IBC 2026 Amendment done under Section 7. Okay, now admission delays are no longer legally tolerated. We are breaking down this amendment which substituted a section 7 section 5, okay, which majorly focus on the strict timeline, mandatory admission criteria or mandatory rejection criteria, and reduce judicial discretion. Okay, here there is a mandatory accountability. How? A strict 14 days timeline is there. Judicial window enforce a written adjudicating authority has to pass either the order of admission or rejection within 14 days. Okay, and it's also defined what are the strict grounds for the admission and rejections without giving any other ground. It's just eliminate all other frivolous and just a tactless delay. It's eliminated by this amendment. And to facilitate this process, we have evidentiary express lane. How? If we have a record with information utility, record of default we have, it's a sufficient proof for the existence of default. So there is no need of lengthy hearings regarding the existence, whether the default exists or not default. Okay. Now, what we have a comparison table over here. First, a 14 days timeline. Earlier, it's also in 2020, 2016, it's also present there, but it is directory in nature, not mandatory in nature. But now it become a mandatory after 14 days if adjudicating authority not passing an order of admission or rejection, they have to record a reason for that purpose. Okay. Adjudicating authority regarding debtor defense, there is no debt and default exist. It's not considered at the time of admission. If information utility have a NESL report, they having a record with the information utilities, they have clear cut sufficient proof of existence of default. So for financial institution, it's a more or less an automatic procedure. If you have a application which is procedurally complete, you have a proof of default with information utility, they issue a NESL report, and RP proposed by you, it's holding a valid AFA and there is no disciplinary proceeding exist against him, then adjudicating authority is bound to admit that petition. There is no other ground they can consider. So it's more or less there is less judicial discretion and more procedural certainty over there. This amendment ensured this. Okay. Now here I illustrated with the help of this 14 day. You have your leverage time. After 14 days, you have to record a reason. It is actually very good because everybody is just saying that there is delay on the part of adjudicating authority. That is a narrative set, but that is not exactly true. Sometimes lawyers are engaged in another court. They are asking for a pass over due to heavy vote. Adjudicating authority cannot pass over the matter because there are n numbers of pending in the list already. So they give a date, another date, they are not complied with the previous order. Maybe they are not filing a reply in times and they are asking opportunity again and again. These all kind of reasons, but nobody is talking about. Now, legislation made it very clear. Whatever the reason of delay, you have to record it. Now, whatever it is, now it's come in a black and white. Everything is on paper, and I think that is very welcome and celebrated amendment. We should appreciate it with all fairness. Okay, next, now this make admission a rule-based exercise, not a discretionary one. I hope I am clear with this point. Okay, There, for admission, as I told you earlier, there is three pillars: occurrence of default, verifiable evidence that the debtor has failed to pay the debt that has become due. Okay, first pillar is that verifiable evidence that the debtor has failed to pay the debt that has become due. First thing, completeness of application, that is a second pillar. RP eligibility, that is a third pillar. Admission mandatory. Impact, there is no other ground for the rejection. All three gates clear. Admission is mandatory and immediate within 14 days. As simple as that. Okay. Next, blocking the delay tactics. Explanation 1, as I'm clearly repeating myself, that explanation 1 clarifies that once the three pillars default, completeness, and RP eligibility are complete, no other ground shall be considered by the adjudicating authority. Debtor can no longer weaponize the admission state to stall the start of insolvency process. Okay, this is made it clear by section 7, subsection 5, explanation 1. Okay. Now, the safety involve rejection and rectification. Clause B is very clear. कि this pillar admit. If there is any missing pillar or defected pillar, then what is the situation? If there is no default, application is incomplete, or application RP is ineligible, then what happens? If there is a procedural technical defect, then adjudicating authority, before rejecting it, give a 7-day rectification loop. Mind it, proceedings here are pause only. The application is not killed. The proceeding is paused for a 7 days. Give a time to rectify it. If you rectified within that time, admitted. If you deemed rectified, then officially it is rejected. Now, what if the application is defective and you deemed this is very welcome provision for the purpose of financial institutions, because they file the application in bulk, or they are very there are structural deficiency as well. We cannot deny with this fact. So if there is some minor defect, they have in a 7 days window to correct it. Okay, and that's prevent the rejection on minor technicalities and increase substantive justice over procedural lapses. Hope I'm clear. Next is the digital express lane. What we do, we for the purpose to decide there is a default, we take okay, what is a contract, and when they default, a date of default, what the amount they default, and how the default is occurred. That constitute a long hearing, on sometimes 2 to 3 hearings to determine only there is a default or not. Okay, but you have expressly, if you have an SL report issued by information utility, you then it's sufficient that there is a default, and admission process for financial institution become quietly automatic. This is our digital express lane. This is our digital India, I guess. So. Okay. If a financial institution furnish a record of default registered with the information utility, the adjudicating authority shall consider that record sufficient to ascertain the existence of default. This is very clear by the explanation second attached to section 7, subsection 5. Okay. Now, mm, as that section 7 cycle I explained here with the help of this. Okay, you application filed, provide evidence, your NESL report, 14 days window begins the moment you file. Adjudicating authority is seeing that three pillars: default, completeness, RP. Okay, no other ground at the stage of admission, explanation 1 says, and mandatory admission. Okay, at a 15 day. Finish, done and dusted. For that, you need to record your default with information utility, with information utilities. If your application is there is some minor defect in your application, adjudicating authority will give you a 7-day window to correct that defect. Okay. And for the financial creditor, hopefully, whenever you file application, file with an ESL report. You have a speediest disposal. Corporate debtor, to stall a admission to stall a insolvency resolution process, they take n number of argument that there is some counter claim, or there is some claim that are not considered, blah blah blah, all are struck down at the point of stage admission. Okay. And resolution professional, you have make sure you have valid AFA and no disciplinary proceeding exist against you. That is, you no longer the gateway to your appointment. That two criteria, it's gateway for your appointment. Hope I'm clear. And let's summarize this amendment in few points. First is 14 days timeline, earlier discretionary, now mandatory, admission based on three conditions. File your application, it's complete, you have a NASL report, and RP, proposed RP have a valid AFA, and there is no disciplinary proceedings pending against him. And if your financial institution filing in bulk, if there is some minor defect, you have a 7-day window to correct that. Okay. And then any other ground of objection to reject that application is eliminated from at the stage of admission. IU records accelerated the admission, and judicial delays provision are strictly structurally strengthened. Okay.